The Fifth Circuit Court of Appeals just dropped an absolute bombshell order that could fundamentally dismantle one of the federal government's most widely used gun control statutes and potentially dozens of other federal laws along with it. We just got the official en banc order in the U.S. v. Squire case, and the Fifth Circuit has officially vacated its prior panel decision to rehear this case en banc. But this isn't just a 2A issue. This is not just a 2A challenge based on Bruin that is driving the case. Instead, the full Fifth Circuit is taking this case to answer a direct challenge to Congress's authority under the Commerce Clause as it relates to firearms. And the question is, why are they suddenly doing this now? Well, as Judge Higginson explicitly pointed out in the dissenting opinion when they granted a rehearing en banc, he said that the Fifth Circuit is doing this to directly answer the call that came from Justice Thomas in the case U.S. v. Hamani. And depending on how this goes, this could be a landmark case that has impacts way beyond just the 2A issues. And now the court has officially issued an order setting the deadline for the first briefs to be submitted to the en banc panel in this critical challenge. So let's break down what just happened in this case, what Justice Thomas said in the Hamani case, and why this issue could potentially upend federal criminal laws and other issues going forward. Now, before we jump into what is going on in this case, if you like this type of content and you want to ensure that you get it going forward, make sure to subscribe to the channel and also turn on all notifications. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. Now, as an attorney myself and as someone who concealed carries every single day, I constantly think about what would happen if I had to use my firearm in self-defense. And as an attorney, that's why I partnered with Attorneys on Retainer. I trust them. They're amazing attorneys. They do only self-defense work, and they're always expanding upon their benefits to give you as much as possible as a member. They just added in a new training division. So if you're interested, if you want to check them out, you can do so using the links down below. And if you sign up using my code ARMSCHOLAR, you can get additional money off of your sign-up fee. Now, to understand how massive this case is, we have to look at the statute at the center of this case, which is 18 U.S.C. section 922G1, the federal prohibition banning individuals with prior felony convictions from possessing firearms or ammunition. Now, for years, litigants have tried to strike down this federal possession law using the Second Amendment. But in this case, U.S. v. Squire, the defendant challenged his conviction by going after the federal government's power to pass the law in the very first place under the Commerce Clause. Recently in June, a 3-judge panel ruled against Mr. Squire, adhering to the decades of precedent relating to the Commerce Clause. But Squire filed a petition for a rehearing en banc in the Fifth Circuit, asking for the full court to step in. And then in July, the Fifth Circuit granted the petition, officially vacating the panel's prior opinion and taking this case for full court review. The entire active bench of the Fifth Circuit will now rehear the case and take a hard look at whether mere possession of a firearm, even one that previously crossed state lines, actually falls within Congress's power to regulate interstate commerce. Now, why did the Fifth Circuit suddenly jump in on this issue, especially relating to the Commerce Clause, after years of various circuit courts ducking this issue? Well, as the Fifth Circuit Judge Higginson highlighted in his dissent from the en banc order, this move directly follows Justice Clarence Thomas and his recent concurrence in the 9-0 ruling in U.S. v. Hamani. Now, in Hamani, Justice Thomas, writing alone, explicitly invited lower courts to re-examine the constitutionality of Section 922G under the Commerce Clause. Under historical Supreme Court precedent, like U.S. v. Lopez, Congress can regulate 3 categories of commerce. First, the channels of interstate commerce. Second, the instrumentalities or persons and things in interstate commerce. And third, activities that substantially affect interstate commerce. In Lopez, the Supreme Court struck down the original Gun-Free School Zones Act, Section 922Q, because it had no jurisdictional requirement showing that the gun affected interstate commerce. Now, in response, Congress revised that statute, slapped in a jurisdictional hook onto Section 922G, meaning as long as a firearm or ammunition even crossed state lines or was manufactured out of state, then the federal government claimed authority over that forever. For 30 years, every federal circuit court accepted that jurisdictional hook, but Justice Thomas questioned whether an item simply having crossed a state line at some point in its history gives Congress the power to criminalize local, purely intrastate possession today. The Fifth Circuit heard Justice Thomas very loud and clear, and they decided to step up and they took this up on review, and they're now going to be considering this issue. Now, Judge Higginson's dissent from the order granting a rehearing shows just how terrified the establishment really is of this case. He wrote in the dissent that just a few weeks ago, Justice Thomas asked lower courts to re-examine the constitutionality of 18 U.S.C. Section 922G under the Commerce Clause. Already, our court answers the call. We imperil much of the United States Code. So as you can see, Judge Higginson is very concerned about the full court reviewing this issue. Judge Higginson argues that if the Fifth Circuit holds that Section 922G1 lacks a sufficient connection to interstate commerce, it won't just affect gun laws. He points out that this could open the floodgates, calling into question federal statutes and countless of other administrative and criminal regulations that rely on that same thin interstate nexus of the Commerce Clause. He raises a lot of apocalyptic questions and raises red flags in his mind about the impact of this case. He asks whether felons in other circuits could move to Texas, Louisiana, or Mississippi to rearm themselves after a ruling like this. Will thousands of existing Section 922G convictions in the Fifth Circuit have to be overturned? And these questions all come in because the federal government has built various restrictions and laws on a house of cards, which is essentially the Commerce Clause. And this judge and others fear that this ruling will all, undo all of that, and the house of cards will come falling down because of this Fifth Circuit review of the case. Now, whether you agree with Judge Higginson's alarmism or the view that this is long overdue and it's a long overdue correction back towards the Constitution's original limits on federal power, one thing is very clear with this case. The Fifth Circuit is preparing to send shockwaves through the federal legal system by reviewing this Commerce Clause issue in relation to firearms regulations. The clock now is officially running on this historic showdown, and under the court's latest order, the opening en banc briefs are now set to be submitted in September. And then also responsive briefs will follow after that, and then soon oral arguments will also be scheduled in New Orleans, and I believe that will probably happen before the end of this year. If the full Fifth Circuit rules that Section 922G exceeds Congress's Commerce Clause authorities, it will create an immediate massive circuit split with every other circuit in the country, forcing the Supreme Court to take this case up and potentially face Justice Thomas's question head on that he just raised. So I'm going to be tracking these supplemental briefs in the Squire case. We'll be tracking the briefs that are submitted, and as this moves forward to oral arguments, we'll be tracking that. But let me know down in the comments section, do you think simple possession of an item manufactured out of state counts as interstate commerce, or has Congress gone way too far with its application of the Commerce Clause? Let me know your thoughts down below in the comments section. But if you like this type of video and you would like to support the channel, make sure to subscribe and turn on all notifications to get these videos when I release them. But as always, thank you so much for all of your support, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.